In the last lesson, we talked about what can happen when no one has authority to step in financially. Today, we are going to look at the specific tool designed to keep your family out of that courtroom, the financial power of attorney. While most people have heard this term, there's often a lot of confusion about what this document actually does, what it doesn't do, and when it stops working. Think of your financial life like a high-security building. Usually, you are the only one with the biometric access to get in, sign the checks, and move the assets. A financial power of attorney is essentially a high-level security clearance you grant to someone else. In the legal world, this relationship has very specific names. You, the person granting the power, are called the principal. The person you choose to act on your behalf is called your agent, also frequently known as your attorney-in-fact. Now, the words agent or attorney-in-fact can be confusing. It does not mean the person you choose has to be a lawyer. It simply means they are an agent you have authorized to perform specific acts for you. This is an authority document, and that distinction is vital. One of the most common myths is that a financial power of attorney is a transfer of ownership. It is not. When you sign this document, you aren't giving your house away to your daughter or handing your bank account over to your brother. You still own every penny and every piece of property. You are simply giving your agent a legal key that allows them to step into your shoes to manage those assets for your benefit. In fact, as long as you're competent, your agent must follow your instructions. You remain the boss. Because you are giving someone else a key to your financial life, the law holds that person to the highest possible legal standard, a fiduciary duty. This means your agent is legally required to act in your best interests, not their own. They must manage your money with care and loyalty. They cannot use your assets for their own personal benefit unless you have explicitly given them permission to do so in the document. So, what does this look like in real life? At a high level, your agent has a few fundamental duties. First, they must follow your instructions. If you have clear values about how your money should be spent or saved, they are bound to honor those. Second, they have a duty of record keeping. They are required to keep complete and accurate records of every transaction they perform on your behalf. They must keep your money completely separate from their own. Mixing the two is a major legal trap called commingling. It is also just as important to understand what a financial power of attorney cannot do. This document is powerful, but it has very strict boundaries. Unless you grant them the authority, for example, your agent cannot make, amend, or revoke your will. They cannot change your basic estate plan or decide who gets your assets after you pass away. They also cannot sign a healthcare proxy or make medical decisions for you. That requires a different type of document we will discuss in a future unit. The biggest boundary of all, however, is the sunset of this authority. There's a common misunderstanding that a financial power of attorney allows someone to wrap up your affairs after you die. A financial power of attorney helps someone manage finances during life, but it ends when the person dies. It is designed to handle your affairs during a period of incapacity, or even when you are simply unavailable, such as if you are traveling abroad. The very moment the principal passes away, the financial power of attorney expires. It effectively dies with you. At that moment, the security clearance is revoked, and the authority shifts from your agent to the executor named in your will. If you want the same person to handle things while you're alive and after you're gone, you must name them in both documents. By watching this video, you now understand that a financial power of attorney is about permission, not ownership. You understand the roles of principal and agent. You know it's active during life and ends at death. And you can explain why it exists without using legal jargon. If you're ready for a small immediate step, I invite you to open your MyEstateKit app and look at the Important People section and review your choices for who you would like to serve as financial agent. For those who want to deep dive, we have resources and guides in the resource section. These tools can help you explain these concepts to the person you're considering for the role, ensuring you're both on the same page from day one. You're doing great. Let's keep going.